Good morning, Mr. Franklin. Good morning, everybody.
Good morning, Chair.
I must give my decision on BAIN's request of yesterday, and then I will have an announcement, a brief announcement to make, and then we can start.
Thank you.
Yesterday morning, I had argument in connection with a request that has been made by BAIN and Company South Africa Incorporated that I should provide it with written permission in terms of Regulation 11 3 A of the regulations of the Commission. That provision reads as follows. And I quote, "No person shall, without the written permission of the chairperson, A, disseminate any document submitted to the Commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such document. And the dissemination of any such document or any portion thereof is a criminal offense in terms of the regulations." BAIN's request was communicated to the Commission by way of a letter dated 26 November 2020, to which I had regard yesterday. After dealing with certain matters in paragraphs 1, 2, and 3 of that letter, BAIN's attorneys wrote the following in paragraph 4. and I quote, "While we await directions from the Commission in respect of the hearing of the application, we also wish to address a request to the Commission in respect of the publication of BAIN South Africa's affidavits." And then in paragraph 5, 6 and paragraphs 5, 6, and 7, it says, BAIN South Africa may wish to publish the affidavits accompanying the application when Mr. Williams begins his testimony before the Commission. That is necessary to ensure that BAIN South Africa is fairly treated by them, the media, and the public at large, given the serious inflammatory and potentially defamatory material contained in Mr. Williams' affidavit and presumably his forthcoming testimony. Fairness demands that BAIN South Africa's version must be publicly available simultaneously with his so that they can be assessed alongside one another. The need for this even-handed release of information is particularly acute where BAIN South Africa will not be able to test Mr. Williams' evidence at the time that he gives it, and will only have an opportunity to cross-examine him later, if at all. 6, we note that Regulation 11.3a of the regulations applicable to the Commission provides that, I quote, "No person shall, without the written permission of the chairperson, A, disseminate any document submitted to the Commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such document," close quotes. The object of that provision appears to be to prevent information submitted to the Commission from being leaked by a third party. We do not understand it to operate against a party like BAIN South Africa, which wishes to disseminate its own affidavits to promote transparency and openness in the Commission's process. Moreover, once Mr. Williams begins his testimony and thereby discloses the evidence he has submitted to the Commission, there is further no reason to maintain confidentiality over his affidavit. Open brackets, bar those portions that BAIN South Africa has sought to withhold permanently from disclosure due to confidentiality or privilege obligations, close brackets, or to preclude BAIN South Africa's reference to it. 7, we accordingly request the Commission's confirmation, alternatively permission, that BAIN South Africa may publish and or disseminate its affidavit as soon as Mr. Williams commences his testimony. Close quotes. The request by BAIN was not based on any substantive application that may have been brought. It was simply based on this request. And as I indicated, I had argument on it. It is quite clear that its basis is simply that BAIN believes that if it is not allowed to publish its affidavits when Mr. Williams gives evidence, that will be unfair in circumstances where Mr. Williams will be giving evidence implicating it. I must indicate that during the course of argument and following upon a remark that I had made, namely whether or not, instead of seeking the publication of the full affidavit, BAIN would be satisfied with the publication of a summary of the contents of the affidavit so that not all details in the affidavit would be published. Following that, counsel for BAIN indicated that BAIN no longer sought permission to publish the whole affidavit, and they confined their request to seeking permission to publish a summary of the affidavit. it will be clear from the letter on which BAIN's request is made that there is nothing special that BAIN relies on, really, to ask for permission. Its counsel indicated yesterday that it had provided comprehensive affidavits, but I do not think that that is a feature that makes its case special. Therefore, this case must be, or its request must be decided on the basis that it's a request for permission as contemplated in Regulation 11.3a, but there is really nothing special in the features of its case. As I read Regulation 11.3, it appears to me that it seeks to lay down what would be the norm, namely that there should be no publication of a document that has been submitted to the Commission unless the chairperson provides written permission, therefore. And it would seem that the chairperson would have to be satisfied about something special with regard to such a request before he provides such permission, because otherwise, if he were to provide permission in regard to a case that does not have any special features, then that would undermine Regulation 11.3a. But the whole case of BAIN is based on the suggestion or contention that there will be unfairness if BAIN is not able to publish its affidavits or a summary of its affidavits when Mr. Williams gives his evidence. In this regard, it is necessary to have regard to the legal framework that governs the proceedings of this commission. Obviously, this commission has to operate within the parameters of the Constitution, the Commissions Act, the regulations promulgated under the Commissions Act which apply to this commission, as well as the rules of this commission. Now, the rules of this commission, particularly Rule 3, makes provision that when a witness has submitted a statement or has made a statement to this commission or an affidavit implicating somebody, that person should be notified of such a statement and that he or she or it is implicated by that witness, and that person must be given a copy of that statement or the relevant portions thereof. And that person then is advised that he or she or it has the rights provided for in regulation in Rule 3. And those rights include the right to apply to the Commission for leave to adduce evidence or to testify, the right for leave to call other witnesses in support of your version, as well as for leave to cross-examine the witness. Indeed, such a person has a right to be present when that evidence is given by that witness. In this case, BAIN has applied for leave to cross-examine Mr. Williams, but that application has not been decided as yet. I indicated during argument yesterday that from my position, that application could be decided even later this week or next week if all the affidavits are in. I understand that Mr. Williams has finished his response to the application, but BAIN is yet to decide whether they will file a further affidavit or not. As far as the Commission is concerned, I will be prepared to hear that application as soon as possible after I've been advised that either BAIN has decided that it will not file a further affidavit or after it has filed an affidavit. But I raised with counsel for BAIN yesterday the fact that BAIN seems not to have applied for leave to testify. And that appears to be factually true. And I think he was not in a position to indicate whether BAIN wished to testify. And I asked him the question whether BAIN would subject themselves to questioning before the Commission, and he indicated that he did not have instructions at that time on that point. Now, the legal framework applicable to these proceedings make it clear that BAIN could have applied for leave to testify before the Commission. And if they had done that, it would have been possible, for example, to include its witness or even witnesses this week, so that their witness or their witnesses, or at least one of them, could well have been able to testify soon after Mr. Williams. But they did not make such an application. If they had made such an application and such an arrangement could have been made and had been made, it's clear that its version could have been articulated by its own witness maybe the same day as Mr. Williams or the following day. The fact that that is not going to happen is because BAIN elected not to make that application. Two, to the extent that BAIN has put its version in the affidavits with regard to Mr. Williams' evidence, when the evidence leader leads Mr. Williams, he will put BAIN's version to Mr. Williams for him to comment on it, and therefore the essential features of BAIN's version will be put to Mr. Williams, and the public will know what BAIN's version is or response is to Mr. Williams' evidence. Of course, if BAIN decides to apply for leave to testify and that leave is granted, and there is no reason why it wouldn't be granted, generally speaking, when there is a witness who implicates them in a serious manner, then BAIN would get a chance to put its version. The upshot of all of this is that, one, any unfairness that BAIN believes will flow from the fact that it can't publish its, or it doesn't, or is not allowed to publish its affidavits or a summary of its affidavits while Mr. Williams is giving evidence. One will be mitigated by the fact that its version will be put to Mr. Williams. I say mitigated, but actually it seems to me that there will be no unfairness because its version will be known publicly. It will be put to Mr. Williams, at least the essential features of its response. But also, if there is any unfairness, it seems to me to flow from BAIN's own failure to apply for leave to adduce evidence, because, as I've said, if it had done so and it had sought to make sure that its witness gave evidence as soon as possible after Mr. Williams has given evidence, that could well have been arranged. That arrangement was not done, flows from the fact that BAIN did not take the initiative to apply for leave to testify or adduce evidence and did not make those arrangements. In the past, it has happened in this commission. That kind of arrangement has been made, and in this regard, I want to refer to the aviation workstream, where implicated persons were given an opportunity to testify as the witnesses that were implicating them were testifying, or soon as possible thereafter. In these circumstances, I'm of the opinion that this is not a case in which I should provide the written permission contemplated in Regulation 11.3a, and accordingly I decline to provide such permission.
Thank you, Chair.
Yes, I will now just make an announcement. I have previously said that the President of the Republic, President Ramaphosa, will appear before the Commission at some stage, and that he had indicated that he would be ready to come and testify and be questioned about any matters that are being investigated by the Commission. Once I had determined the dates, I have now determined the dates when he will appear, and I deem it appropriate that I should make this announcement publicly. I have determined four days. The dates are 22 and 23 April, and 28 and 29 April. On the 22nd and 23rd of April, those dates are effectively provided for the ruling party, the ANC, because I have also indicated that this commission cannot complete its work without the ruling party also coming to give evidence and deal with certain matters. And I was assured by its president that it would come, and it was prepared to do that. I understand that President Ramaphosa will testify representing the African National Congress, but I have indicated that from the Commission side, the President will have to testify as President of the country and former Deputy President of the country, but it's up to the ANC to provide its witnesses. But I understand that he will lead that delegation as well in his capacity as President of the ruling party. But the dates of 28 and 29 April, that is when President Ramaphosa will be testifying in his capacity as President of the country. So I thought I should just make that announcement so that the public is aware. Yes, we may proceed.
Thank you, Chair. Chair, before we continue with the resumption of Mr. Williams's evidence, as you will know, there are two further SARS witnesses who have been scheduled to testify today, Mr. Symington and Mr. van Locherenberg. Both were required to be here at 10 o'clock this morning. Because of the way that events unfolded yesterday, Mr. Williams's evidence is not yet complete and will still take some time. So the request, Chair, is for you to excuse the witnesses until further notice. We will be in touch with their legal representatives and let them know our estimation of when it is that they will be required. But we would just ask that the Chair formally excuse them from continuing in attendance right now. The second issue is that there are a number of my learned friends who are here who represent those witnesses. In addition, there's a colleague who represents the State Security Agency, and I believe that they would like to place themselves on record.
Okay, one, I will excuse those the witnesses for today who need to be excused from attendance at the moment, and they will be advised by Mr. Franklin through their legal representatives in terms of when they should come back. So that's done. And then the legal representatives who need to place themselves on record, you may do so from where you are if your mic is working.
Good morning, Chair. My name is Greg Faree. I'm an advocate at the Johannesburg Bar, and I represent Mr. Symington.
Thank you. Thank you.
Good morning, Chair. My name is Bernard Hotz from Worksman's Attorneys. I represent Mr. van Locherenberg.
Thank you very much. Okay, are we done? Is there somebody else? Oh, you need a mic that is working.
Good morning, Chairperson. My name is Mtetheleli Philip Mahlatsi. I'm here together with my learned colleague, Mr. Deeplal. We are here on behalf of the security agency in South Africa, particularly Mr. Jafta. There are submissions that we made. In fact, we did an application. I'm not too sure if the chairperson would have seen this application.
I've seen the application, yes.
My instruction, or rather our instruction, is to address the chairperson insofar as the concerns that are raised in the application.
Yeah, don't do that now because we are not going to deal with Mr. van Locherenberg's evidence now. I think once we are done with Mr. Williams' evidence, we can then look at that application.
Thank you, Chairperson.
Okay, all right. Thank you. Are we done with legal representatives who wish to place themselves on record? It looks like we are done. Okay, Mr. Franklin.
Chair, I appear today for Mr. Williams.
Where are you?
I'm right behind.
Okay.
It's Advocate Ngujana.
Yes.
I appeared before you previously when the matter was postponed.
Yes. Were you here yesterday?
No, yesterday I was not
you
here.
Were not here.
My attorney was here.
Yes, I was wondering how I missed your presence.
Apologies, Chair.
Okay, all right. Thank you. Thank you. Yes.
Chair Isabel Goodman, Mr. Cockrell and I were here and remain on record for BAIN.
Yes, okay, no, thank you. Okay.
Thank you, Chair. One matter of procedure. We intend calling Mr. Symington next, and so I would ask that any such application as needs to be argued in relation to Mr. van Locherenberg take place immediately prior to him being due to give evidence. So just to let my learned friend know.
Okay.
And we will keep in touch with him.
Yes.
in order to let him know what our estimate is of,
Yeah.
of when that is likely to be.
Yeah.
There are also ongoing interactions between the Commission and the agency in an attempt to reach some accommodation that will obviate the need for an application. But we will obviously report on
Yes.
that to you.
Yes. No, that's fine. I would have imagined that the kind of arrangements that were made previously when there was evidence concerning the State Security Agency would have been easy to agree upon, but I'll leave it to the parties to talk about it.
Thank you, Chair.
Yeah.
All right, if we may then call Mr. Williams for him to
Yes.
continue his testimony.
Yes. Good morning, Mr. Williams.
Good morning, Chair.
The oath you took yesterday will continue to apply today.
Thank you, Chair.
Okay, all right. Mr. Franklin.
Thank you. Good morning, Mr. Williams.
Morning, Mr. Franklin.
We continue with your testimony. You recall that yesterday we had reached the point where I had led you through the various operational and other strategic plans that had been compiled by BAIN South Africa in relation to the restructuring of the South African economy and also certain plans in respect of SARS itself. You recall that?
I do, Chair.
And I had asked you to indicate to the Chair whether, in your experience, that was an example of typical CEO coaching or not.
That's correct, Chair. I recall that.
But I'd like to move on from that, and I'd like to deal with a topic which relates to BAIN's knowledge of Mr. Moyani's appointment before that was announced publicly. And to that end, may I ask you please to firstly turn to AW 67, which appears at page 420 of the SARS Bundle 01. So I will be principally in SARS Bundle 01 until I tell you otherwise. Do you have page 420?
I do, yes.
That is a document which we referred to yesterday. Just to remind you, it was Mr. Masoni's partner self-assessment in December of 2013. And if I could ask you to look, please, at paragraph 2 on page 421. You have that?
I do, Chair.
Yes. The second sentence reads as follows: the person we prepared the document with and who pitched it to the SA president is most likely going to be appointed as commissioner in the next few weeks / months, and BAIN will be assisting him should he get the job. Just stop there. It would appear from this that BAIN had information in December of 2013 that Mr. Moyani was likely to be appointed as the new SARS commissioner. Is that your understanding?
That's how I read it, Chair.
Then would you look, please, at AW 86, which is on page 470. That is an email chain. At the bottom, it is Mr. Franzen, who sends an email to Mr. Masoni on the 4th of April 2014, and he says, "Ciao, just wanted to check how your, inverted commas, big meeting, close inverted commas, went yesterday. Take care." There is then a response from Mr. Masoni to Mr. Franzen.
Mr. Franklin, I'm looking at page 470. Is the right page?
That's right, 470. I took the witness first to the bottom of the page, which is the first short email, and then I'm looking in the middle of the page.
Okay, now I can see. Okay.
Thank you, Chair. Mr. Masoni responds to the inquiry, thank you, Fabrice, it went very well. And then the first dash is SARS is, looks like a go-go, sorry, SARS is a go right after the elections. Central Procurement Agency, he loves it, wants an implementation plan, wants to accelerate Phoenix. Dash asked us to organise a workshop with the new cabinet of ministries after the elections, brackets, sort of new strategy by sector, plus minus, looks like RDO stroke mobilisation. So I'd say very well. I will update the team on next call. In the context of your analysis of the information provided to you, can you elucidate what is being said here?
Chair, my understanding of firstly the meeting that is referenced here is a meeting between Mr. Masoni and former President Jacob Zuma that happened. And obviously during that meeting a number of things were discussed, and he's giving an update to his team of what was discussed or what was agreed. So it certainly seems to me that from that meeting, Mr. Masoni is given the impression that SARS is a go, and my understanding of what he means by SARS is a go is that BAIN was expecting to be doing work with SARS, and they were given some assurance of that. Also in a sense that BAIN was expecting that Mr. Moyani was going to be appointed as the commissioner, and that seems to be, that's a go. In fact, my 2 points should be reversed. Was first that he seemed to get assurance that Mr. Moyani was going to be the commissioner, and therefore BAIN would be getting that work. But I think the points below that, I think, make reference to some of those plans we discussed yesterday. So by this point, Mr. Masoni and BAIN had presented the Central Procurement Agency plan, and we see that the President seems to like that and wants an implementation plan, which indicates that the President supported the concept of this that BAIN had presented, and now wants to move towards actually making it happen. I think the reference to Phoenix we discussed yesterday, so those plans we saw were presented to the President 3, 4, 5 times, and he wanted to move along with that. I think the last point, just RDO, is typically, it's a results delivery office, the program management office. But that begins to, again, indicate this point about, let's get on with things now. We've discussed the concept, so we now want to act. So they're talking about BAIN setting up a program management office to put some of these plans into action, and particularly to start with a workshop with cabinet ministers to discuss some of these plans that have been presented to the President. Chair, that's how I understand this email in the context of what I know.
As at this date...
Just 1 second, Mr.
Sorry.
The technicians, if they could switch off the screen here, it doesn't have to be on. It's distracting me. At least the witness is here. I can look at him here. Okay, let's proceed. I see, Mr. Williams, that Mr. Friends and Members, I'm not sure which one is the surname, which one is the name.
Fabrice Franzen.
Yeah, that he refers to the meeting that is supposed to have taken place the day before as the big meeting, in quotes, the big meeting. I wonder whether you took the trouble to go back to that schedule of meetings between Mr. Masoni and the President and other people to see whether there was any meeting on 3 April 2014 that is reflected, because the date for this big meeting would have been 3 April, since this email is on the 4th.
Chair, I just want to check the notes. I would have cross-referenced it.
Yeah, okay, it can be checked for later. It would just be interesting.
Yes, if just to direct the witness, in order to answer the Chair's inquiry, the tracker table is at page 306. on page 307, there is an indication of a meeting on the 3rd of April 2014 at the bottom of the page. Do you see that?
That's correct, Chair. I do see it. And in fact, the ad confirms that what was discussed was the workshop with the cabinet ministers and the Central Procurement Agency.
Yes.
So it cross-references.
Yeah, okay.
Thank you. Then, please, if I could ask you to look at AW 106, page 572. That's another email string. The first of those emails at the bottom of the page is from Mr. Masoni to Mr. Beaumont, and copying others, dated the 28th of August 2014. And he says, guys, just had a call and heard that the SARS announcement should happen tomorrow or Monday. Meeting later in the office to discuss also procurement process. Fabrice, Stefane, how many teams do we have? And then he continues. Then in the middle of the page is an email from Timpano to Masoni, copying others, dated 28 August 2014. Vittorio, that's a great news. The latest thinking was to start with one team, etc., for 3 months and do fundamentally two things. One, run a full operational strategic assessment of SARS. Two, assist Tom in starting properly his new role, brackets, direct CEO support work. We will then be able, based on the operational strategic assessment, to build up the platform for a broader SARS transformational program, brackets 6 to 12 months plan. So just pausing there, it would appear that BAIN had received information that the SARS announcement was to take place imminently.
That's correct, Chair. That's how I read the email.
Could I ask you, at this stage, was this news public that Mr. Miani was going to be appointed as Commissioner?
In August of 2014, I don't think so, Chair. I think it was announced in September of 2014.
All right. So it certainly wasn't in December of 2013, the document I took you to, or April of 2014.
That's correct, Chair. It was not public who the new Commissioner would be.
Yes. Could I ask you for your comment on the fact that BAIN, as a consulting company, appeared to have been privy to information about an appointment of the new Commissioner of SARS before the public of South Africa knew about it?
Chair, I mean, I think that's highly unusual, I guess, for anyone to know something that hasn't been announced publicly, something of this seniority, this person, the importance of the role. So I think for any of us to have known that, I would think would be problematic. The fact that a management consulting firm, the fact that a non-South African management consulting firm, staffed by non-South Africans, seem to have this non-public information and access to it before any of us, I personally, as a South African, find problematic. And I think in terms of normal business practice, that also seems strange to me. One could argue, well, maybe someone at BAIN had a friend inside the presidency, so they could have known. But my understanding is from this trail of events, it seems they had access to a channel of information into our public institutions where they got this information.
Yes, then yesterday you made a comment on one of the emails which I showed you, and you said that it appeared that BAIN had an insider at SARS who was providing information, and you identified that person as Mr. Jonas Makwakwa.
That's correct, Chair.
Please would you look at paragraph 113, page 58 of your affidavit.
Of course, it's, I guess you mean page 58 of the bundle.
Page 58 of, yes, indeed.
Of the bundle.
That's correct. I'm sorry. And that at page 58 of the bundle appears paragraph 113 of your affidavit. You have that?
I do, yes.
Thank you. You say there that the level of specificity with which BAIN was able to offer action guidance to Moyane would only be possible with access to inside information at SARS, and as it turns out, this is exactly what happened. Franzen indicates in an email to Kennedy on 3 September 2018 that BAIN had multiple meetings with Jonas Makwakwa, head of internal audit at SARS, and that Makwakwa was a, inverted commas, deep throat, close inverted commas, relaying information about events at SARS to BAIN and Moyane. Now, if I could just stop there, would you turn, please, to AW 96, page 509.
Is that 509?
Correct. That's an email dated 3 September 2018 from Mr. Franzen to Stuart Min and Chris Kennedy. Now, this, of course, is at the time of the BAIN investigation and the Baker McKenzie investigation. Is that correct?
That's correct, Chair, and the Nugent Commission.
Am I correct that this reflects information that had been uncovered by the investigation by Baker McKenzie on behalf of BAIN?
That's correct, Chair. So Fabrice Franzen had been asked to send the legal team his recollection of events, and so this email he sends to them.
Please look at the fourth bullet point. So Mr. Franzen reports to these two members of BAIN Legal. In 2014, Vittorio also had multiple meetings with Jonas Makwakwa, the future head of BAIT. Do you know what that is?
It's business and individual tax.
Is that at SARS?
At SARS, the largest unit within SARS in terms of tax collection. Chair.
At that time, head of internal audit at SARS. First bullet point, these meetings were with Vittori, Moyane, and Makwakwa. They also happened in plain sight of the office. And then second bullet point, as Vittorio indicated during witness preparation, Makwakwa was playing a sort of, inverted commas, deep throat, close inverted commas, on events, I think that's meant to be, happening at SARS and feeding into Moyane. So that would appear to confirm what you have said in your statement at 113. Your comment on BAIN having access into a state organization via a deep throat in preparation for an assignment there?
Chair, firstly, BAIN had made it and continues to assert that all these materials prepared for Mr. Moyane was based on public information. So it was outside in, they keep calling it an outside in document. It's all public information, and so that's they were using to prepare this document. And as we indicated yesterday, and you can see from some of the materials, it appears that there's actual information that no one outside of SARS could possibly know. So there was this level of specificity. And as we see from these emails and the one document we reviewed yesterday, which was actually a document prepared by Mr. Jonas Makwakwa, which was fed to BAIN. So it's certainly the first idea that BAIN only relied on public information, for me seems to be incorrect, because here's evidence that they had access to information from the inside of SARS. Here we've got Mr. Fabrice Franzen, who led BAIN's operational project day-to-day at SARS, saying that Mr. Masoni had met with Mr. Makwakwa multiple times. Again, Mr. Masoni said he only met Mr. Makwakwa once to discuss some personal matters. And this phrase, deep throat, which I find quite a disturbing phrase as well. But in Mr. Franzen's mind, Mr. Makwakwa was obviously feeding information multiple times to Mr. Moyane and to BAIN. Chair, the fact that, to the evidence lead's question, I'm not a legal expert, but my sense is that that someone, a senior executive in a public institution, was feeding sensitive information to outsiders, to me, is troubling. I also understand that it's illegal to do that because of SARS. So I think my interpretation of this is that this is troublesome, this is worrying.
Well, I see that this email also reflects that they knew that Mr. Makwakwa was the future head of BAIN, which you said is business and individual tax, is that right? A section at SARS, is that right?
Chair, I read it differently to that. I think he's writing with hindsight.
With hindsight.
He's writing with hindsight. So he's saying Makwakwa, the person who would later become the head of BAIN.
Oh, well, if that is what it means, it is certainly strangely to me, because when you talk about the future is what will come after the day on which you are talking. Mr. Franklin, is that your understanding as well?
Yes, I understand, Chair, that this is the BAIN people writing in 2018. And what they are reflecting is what the original position held by Mr. Makwakwa and what he subsequently held.
I think you are right. So he is talking about the person who would later become the head of this section.
Yeah, that's good.
Yeah, okay. It's just a way of putting it that may be confusing.
Yes, one has to keep an eye on the date and distinguish between what is the original email and what is produced in the Baker McKenzie investigation, Chair.
No, I think the date solves it, yeah. Okay.
In your experience, what would be the normal source of information for a consulting company like BAIN in relation to a potential future assignment?
Chair, it would be public information, and it would be based on the experience of consultants who have worked at that organization in the past. Even that is very sensitive, the latter. Because if I worked at a client, I agree with that client that everything I've gained there is confidential. So typically, as a consultant, I would form a very high-level view of what my takeaways are, rather than the details. But it would be public information, and it would be based on the consultant's experience in that organization or in that industry.
Thank you. I'd like to move on to another topic, which is the tender procedure which preceded BAIN's appointment. Just to remind you of the dates, Mr. Moyani was ultimately appointed as the new commissioner on the 23rd of September 2014. SARS issued a request for proposals on the 12th of December 2014, and BAIN was awarded its first contract assignment in January of 2015. Against that background, could I ask you please to turn to Annexure AW108 at page 580. Firstly, could you look at page 581, which is part of the same annexure? This is an email from Marilyn Batonka from Baker McKenzie, dated 22 November 2018 to, amongst others, you. And the attachments are Project Arrow, subject is Project Arrow update, and there are various attachments including Project Arrow review stats and 2018.11.21 index of documents for client review. Is this another one of the updates you received from Baker McKenzie regarding the progress of their investigation?
That's correct, Chair. This was the way Baker McKenzie sent updates to just, as a way to summarize their progress in the investigation.
And what was Project Arrow?
So Project Arrow was Baker McKenzie's name for their investigation that BAIN had hired them to conduct into their work at SARS and other SOEs.
All right, this is much the same as the tracker document scenario.
That's correct, Chair.
Please then turn back to page 580. That is headed Project Arrow, Index of Key Documents, Privileged and Confidential. and then there is some handwritten annotation. Can I direct your attention to the bottom block on the page? On the far left-hand side, there is a date. Looks to be 25/09/2014.
That's correct, Chair.
And then it says under document, diary entry in Franzen's calendar, and then it's S.RFP. And then in the far right column, additional comments, the following is said. And could I just, before I read out that comment, who is the author, as you understand it, who is making these comments?
This would be an investigator from Baker McKenzie, Chair.
Right. What is recorded by the investigator is Franzen confirmed during his interview that he did in fact draft the, inverted commas, South African Revenue Service Strategy and Operations Review - request for proposal, close inverted commas, dated October 2014. Do you know what document is being referred to there?
Chair, it appears that Mr. Franzen had drafted the request for proposal that SARS would issue to call for proposals to do work at SARS.
Would you please turn to page 574, which is AW107. Is that the document which is referred to in the strategy review document that I referred you to earlier at AW108?
Correct, Chair. That's how I understand it. This was the document that was referred to by Baker McKenzie's investigators.
And just for the sake of completeness, the document is written South African Revenue Service, Strategy and Operations Review, request for proposal, October 2014.
Thank you, Chair. So the Chair has read out the heading of the document at page 574. Could I ask you then to go to the content of that document? And would you, in summary, tell the Chair what it deals with subject matter-wise?
Chair, the document describes quite a comprehensive organizational and strategy review of SARS and redesign of SARS. So it starts from, they describe the scope of work and deliverables, but it starts with looking at SARS collection capability and how that can be improved. It talks about how SARS operational performance can be enhanced. Then there's a section on SARS infrastructure and how that can be improved. And it's mainly drafted as questions. So is the IT infrastructure adequate to sustain SARS in that context? And then there's a section on organization and governance. And so my understanding of this document is, well, firstly, it's something that you'd expect SARS to draft, not BAIN. But it covers this broad spectrum from end to end almost of the things you would think about if you're going to restructure. Let me take that back, Chair. If you're going to think about massively, significantly improving the performance of an organization. But of course, it also includes parts of thinking about SARS structure.
All right, could I take you back then to paragraph 1, context of the request for proposal. There is some background, and in the 4th paragraph it is said, in this context and in order to help the new Commissioner frame the next of SARS transformation agenda, the service is considering the support of an external third-party consulting firm with the following 3 objectives. So it would appear that the document contemplates the appointment of an external consultant. Is that correct?
That's correct, Chair.
You've dealt in paragraph 2, the scope of works and the deliverables. Then look at page 577, selection process and criteria. It is recorded this process will be a closed tender. This RFP has been to a selected list of consulting firms that are part of SARS consulting panel, and then it gives a number of characteristics or criteria of the consulting firms, as I understand it, that they must meet. Is that how you see it?
That's correct, Chair.
And then at the bottom of the page, a number of dates are given for the selection process. RFP issuance, that's in the future, Q&A session, proposal submission date, engagement to start no later than 10 November 2014. Your comment on BAIN, which appears from this document to be one of the potential consulting firms that might be appointed pursuant to a request for proposal process. Your comment on it having drafted this request for proposal?
Chair, I find that, again, improper in two senses. One, it's anti-competitive that one of the potential consultants, among others, is able to draft the rules of the game effectively for which they're going to be judged. So that's anti-competitive. Again, secondly, problematic for me because we're dealing with a public institution in SARS, that SARS could allow BAIN to draft this document, which then guided the actual RFP which SARS then issues.
Well, it's interesting that is what seems to have happened here, because it's not the first time I hear evidence of that kind. I had similar evidence in relation to allegations of corruption relating to SASA in its dealings with the Department of Correctional Services, also where a potential service provider is allowed to basically prepare the request for proposal or the specifications, what will be required. So, yes.
Thank you, Chair. Following on the Chair's theme, would you look at AW 109, page 583? This is an email from Mr. Masoni to Mr. Meehan, dated the 18th of November 2014, and I direct your attention to the second paragraph. Before I read that out, do you know what the subject matter of this email is?
As I understand the context here, Chair, BAIN was expecting to be doing work at Telkom, expecting to be doing work at Telkom, and Mr. Masoni is trying to get his boss to, I think, strong arm some of their colleagues around the world to send capabilities, because BAIN didn't have the capabilities in South Africa to do the work that Telkom required.
How do you discern from this email that it relates to Telkom? There's a reference to an RFP for that famous separation project is out and actually includes the National Broadband Plan. Is that the...
That's correct, Chair. Separation project was one of the projects that BAIN had been expecting to come from Telkom. And of course, talking about broadband would be linked to a telecommunications company.
All right, in that context of a Telkom request for proposal, I direct your attention to paragraph 2, which says, as much as it is, inverted commas, designed for us, those inverted commas, brackets, and allowing for a piece of the work to be done by the Deloitte regulatory team, close brackets, we need to make sure they feel comfortable with the team and our expertise, brackets, and we know that we can't claim to have done much on the specific topic, those inverted commas. The reference to design for us, what do you understand that to convey?
Chair, I understand that to be that this RFP for work to be done at Telkom, BAIN described as that RFP was designed for BAIN. And so again, this idea of BAIN influencing RFPs from public institutions seemed to have been fairly widespread. I I think also just related to that, this idea, your organizations hire management consultants for their particular expertise, because organizations have people who should be running their businesses. You only go outside when you want some particular expertise. And here you have BAIN admitting they don't have that expertise, and so they're trying to find it somewhere else in the BAIN system. Because, like he says, and my understanding is, as much as it is designed for us, meaning we're almost assured that we're going to get this work, but we still want to kind of show that we've got some people who know something about telecommunications or broadband.
Right, then please go to paragraph 128 on page 64 of this bundle. What you've done is to collect together various examples highlighting the engagements between SARS and BAIN around procurement. Is that correct?
That's correct, Chair.
Going to the first subparagraph, you refer to an email of, it is AW112 at page 590. So if you could just keep your finger at paragraph 128, but turn to page 590. And there is a request at the bottom of the page from Ms. Mogogodi Dioka, dated the 2nd of December 2014, and she asks Mr. Masoni as follows: Hi Vittori, just a note to request any current public entity relationships and references you have. That's a request for information at a time prior to the RFP having been issued, is that correct?
That's correct, Chair. You would typically ask for references if you're going to hire an organization so that you can speak to others who have worked with them to just establish their credentials.
Right. Then in 128.2 on page 64, you make reference to an email of the 4th of December 2014, which is the next annexure AW113 at page 592. Again, an email string. I direct your attention firstly to the bottom of the page, Masoni's email to Mr. Sipho Maseko, dated the 4th of December 2014. And what Mr. Masoni says in the second paragraph, I received a call from SARS, brackets the acting COO, close brackets, who told me that they would like to use Telkom's contract to give a mandate to BAIN. Apparently law, brackets or practice, close brackets, says that they can piggyback another SOE. This will enable an immediate start, avoiding long and complicated tender processes. Stopping there, do you understand the reference to piggybacking on Telkom?
Chair, not an area of my expertise, but I do understand that there are provisions for state entities that if one state entity has a contract with a provider, another state entity can piggyback on that contract to procure services from the provider. So I think this is the attempt here, is to piggyback off Telkom's contract for SARS.
Yes, as it turns out, was that method used?
Chair, it was not used. It was determined by, in fact, I think Mr. Maseko and Telkom people say that piggyback arrangement isn't appropriate, or isn't applicable to Telkom, so SARS couldn't use that avenue.
As it transpires, BAIN were awarded their first contract in January of 2015. Could I ask you please to go to AW130 at page 630. That's a document which is headed, "The BAIN team brings considerable experience and expertise to the table." Do you know what this document's purpose is and who it was sent to?
So, Chair, this document would have been part of BAIN's submission to SARS in response to the RFP. And so this is BAIN demonstrating, or apparently trying to demonstrate their expertise that might be applicable to the work at SARS.
All right, if we look at the members of the team who are reflected here, we have Mr. Masoni, Mr. Franzen, a Neville Eisenberg, and then a Mr. Bour, B-O-U-R, who we have heard of before. Do you know those gentlemen?
I know the first two, Mr. Masoni and Mr. Franzen. Yes. I haven't met the other two, the last two.
Are you able to comment on the expertise and appropriateness of this team in relation to an assignment to a country's revenue collecting authority, SARS?
Chair, when you conduct a consulting project, the main source of the expertise on the consultant team derives from the partners, from the more senior people in the team. So if I'm looking to hire a consulting team, I would look at their partners first. And so I would be looking at Mr. Masoni and Mr. Franzen to see what expertise do they have in working with tax authorities around the world, in Africa, or actually at SARS. And if you look at the expertise of Mr. Masoni and Mr. Franzen, there's no apparent expertise of working in tax agencies anywhere. My understanding of Mr. Masoni's expertise is in telecommunications. My understanding of Mr. Franzen is in financial services, but mainly in banking. That is not tax authority expertise.
All right, I wish to take you out of bundle SARS 01 for a moment and ask you to look at SARS bundle 03. You have that?
I do, Chair.
Thank you. Please look at page 196 of SARS 03.
Is that 196?
Correct.
Okay.
Mr. Williams, that's an affidavit deposed to by Ms. Diorca on the 16th of February 2021. You've seen that document?
I have, Chair.
You'll recall that Ms. Diorca is the person who asked for the references in AW 112.
That's correct, Chair.
And she was at the time SARS's executive, from SARS's executive procurement department.
That's correct.
I just want to put this affidavit to you because Ms. Diorca has set out her version of events, specifically in relation to paragraph 128.1 of your statement. And the essence of Ms. Diorca's contention is that she denies any irregularity in relation to having asked for the references that are referred to in her email. If you could just read the affidavit to yourself, and please give the Chair such comment as you have.
Chair, what Ms. Diorca says, she's referring to a paragraph in my affidavit. So in my affidavit, I say it seems problematic that Ms. Diorca sought references from BAIN even before the RFP process had begun, even before SARS had issued the RFP. She was already seeking references from BAIN. So why would she be seeking references from BAIN if the RFP process hadn't even started? And that was a statement in my affidavit. Her response is that she makes no reference to an RFP process in her email to BAIN. So she discounts my reference to an RFP process. And she's absolutely right. She makes no reference to RFP process in her email. It doesn't change the fact that she is still asking a service provider for references. And her explanation is that she was actually asking for references because they were still busy pursuing the piggyback avenue. So she doesn't deny, in my understanding, that she sought these references for procurement purposes.
It has to be so, on her own version.
Absolutely.
Yes.
And she does say that she doesn't deny it was for procurement purposes.
Yes.
That still raises the question of why would SARS be seeking references from BAIN before any work had been done or any tender process or contracting process had begun. It seems that they'd already decided as early as 2nd December 2014 that BAIN would be their consultant.
Right, thank you. So, in a word, is there anything you wish to change in relation to what you said in paragraph 128.1, having read Ms. Diorka's affidavit?
Chair, the essence of that paragraph wouldn't change, which was that it appears SARS had already decided that they were going to procure services from BAIN for this restructuring work. I make reference to the RFP process, but obviously there was a channel being sought even before the RFP process to try and get BAIN in as the consultants.
All right. Could I then take you back to 128 in SARS Bundle 01, which is where we were before we deviated to Ms. Diorka's affidavit? What you have done there.
Going back to his affidavit?
That's correct, Chair. You have set out a chronological list of various interactions relating to procurement.
What was the page?
64.
64. Thank you.
And you can confirm there were various phases to the BAIN assignment at SARS.
That's correct, Chair.
All right, please look at 128.3, where you say that on 12 March 2015, Masoni sent an internal mail to colleagues informing them that Jonas at SARS, presumably Makwakwa, informs him that Moyani met with SARS procurement department and that he doesn't see a problem. And that is a reference to AW116. What do you make of that, and do you know what context is being referred to here?
Chair, it might be, if I may, to just perhaps take a small step back just to describe the overall procurement process, if I may. So the RFP that SARS issued in December 2014, that's the RFP that BAIN and other consulting firms responded to. That was for a 6-week piece of work, which they refer to as the diagnostic. And the bid adjudication committee at SARS expressed some discomfort with parts of BAIN's proposal. And I've seen this from submissions to the Nugent Commission, which are public. But they go ahead and agree that BAIN can be appointed, but they make it very clear, they stipulated that if there's any additional work, SARS must go back to the market to open tender. And so that's that first piece of work, that 6-week piece of work, which started in January 2015, and by the time we get to this stage, March 2015, that piece of work would have ended. So now the emails and the discussions are, from BAIN's side, how are we going to extend this? And we know that BAIN ends up working at SARS for 27 months, having only ever been awarded a contract for 6 weeks. This contract was awarded for 2-point-something million rand, and at the end they were paid 164 million rand. So I was very interested to understand what changed from being awarded a 6-week contract to working there for 27 months. And an email like this, that in paragraph 128.3, gives us some indication of what was happening inside SARS, because it indicates that the commissioner had gone to speak to the procurement people within SARS. Now, I've never worked at SARS. I actually haven't worked at in any government entities, but my understanding again is of the PMFA and how procurement rules work is the procurement department and the legal teams make those decisions on procurement. You wouldn't have the commissioner going in and intervening in a procurement step. So here's an email from Akwakwa to BAIN saying, don't worry about this extension. We're going to make a plan because the commissioner has gone to see procurement.
Right, then AW117 on page 600, which is an email from Mr. Eisenberg to Masoni, dated 13 March 2015.
Sorry, what page?
It's 600. And there Mr. Eisenberg says to Mr. Masoni, spoke to Jonas, here is the situation on procurement. First dash, they have to run a procurement process for phase 2. In particular, they feel need to be bulletproof. Jonas mentioned they received some letters of complaint already from some of the losers of the original process. They believe it will take 4 to 6 weeks. In the meantime, they want us to run 2 of our 4 streams as an extension of phase 1, org stream and RDO setup, but not collection full potential or network of the future stroke process involvement. Are you able to shed light on what is being discussed there?
I'm trying from my side, Mr. Franklin, to see where you are reading at 600.
I'm sorry, it's there's a opening paragraph, spoke to Jonas.
Yes.
Then there's a first bullet point,
Oh, okay.
second and third.
Okay.
I read the first
Okay.
3 bullet points.
Thank you.
Chair, my interpretation of the email, I think two points jump out for me. The one is that SARS is now telling BAIN, look, we have to run a public procurement process if we're going to go into phase 2 to continue the work. But secondly, what they seem to have done, and they've become quite clever, they've now said, because the first contract was what they call phase 1, the 6-week contract. They now, between BAIN and SARS, say, well, actually, there's phase 1A and phase 1B. And so we're not extending the contract, it's not phase 2, but we're doing this phase 1B. And so we're still covered by the initial contract. And so they want us, so he's saying, SARS want us to run 2 of our 4 work streams, so continue the work as an extension of phase 1, because it's now phase 1B.
Right, then AW118, page 602, is a further email from Mr. Eisenberg to Mr. Masoni, dated 19 March 2015. You have that? And he says, Ronald just called to inform me that they have decided they need to run an open tender process and that no extension is going to be possible. They still aim to be ready to start with the successful provider by May 1st. And he said they still hope that we are the winning bidder. So it would appear that they came to a realization that they would have to run a tender process. Is that how you understand this?
There is, how I understand it, Chair, which again is the fact that there are SARS executives all just trying to not make this an open tender process. For me, it would be just a natural thing to be doing. We had the 6-week contract, it is done. The understanding was we need to go back into the market for tender process. There shouldn't be a debate about it. So the fact that all this back and forth is going on to try and avoid it already, for me, is problematic. But it seems now they've been told by their legal team or procurement team they have to go to the market in an open tender. But still indicating that still like BAIN to be the winner. Open tender process doesn't have a preferred winner, as I understand them.
Then AW119, page 604, from Mr. Masoni to Franson and others, dated 1 April 2015. Seems we are seesawing back and forth because now what is written is the following. Spoke with Jonas at SARS now. They might have found a way to legally resume work without tender process. Commissioner needs to make a final call, but we should be ready to restart for phase 2 by mid-April. Is that your understanding that there is now an attempt to engage BAIN for another phase without a tender process?
That's correct, Chair. So again, indication of this internal battle going on. And I imagine it's executives going to the procurement team, trying to find ways to move them, and they seem to have found a legal way to have done that.
Then AW120 at page 606, Mr. Bois writes to Masoni and others on the 9th of April 2015 and deals with procurement process in the first part of that email. You see that?
I do.
And he says in the second bullet point, Jonas does not anticipate any issue. He said, quote, there is one person that is making some noise, but he is not even a voting member, close inverted commas. They have had legal advice and it's okay to go through without an RFP. He said we should be, inverted commas, ready to run, close inverted commas, when the decision is made. Your understanding of what stage the parties are at by 9 April?
Chair, it does seem that they've now found this, quote, legal way to move, to proceed without going to the market, without going with RFP. Chair, if I may, Advocate Franklin
Yes,
will guide me. I've got some understanding based on reviewing the transcripts and submissions to the Nugent Commission by National Treasury, Mr. Soli Chitangano, of what was happening behind the scenes. And if relevant, I can share that.
Yeah.
So this legal way that they seem to have found was for SARS to declare this BAIN project an emergency. And in fact, they invoked some rule that says you can extend the contract if it's an emergency, one, or if it's single source. So if there's only one company in the country that can provide these services, you're allowed to then extend it. And my interpretation is neither was this an emergency. Restructuring SARS, no one would be saying SARS drastically, urgently to be restructured, or that BAIN was the only organization in the country that could do that. But that, I understand from Mr. Chitangano's testimony, was what this legal route was.
Thank you. And then AW121, page 608, an email from Mr. Bois to Mr. Masoni on the 9th of June 2016. Do you know what phase had been reached by this stage, 2016?
So, Chair, this is now over a year later from the discussion we've just been having. So this is the third phase of BAIN's work. So initial 6 weeks, then they got 2.6 million, then got this emergency extension for a year and a bit, and that they charged 150 million. And now they come to the end of that second phase, and now the problem arises again of how they're going to extend it one more time without going to the market. In fact, Mr. Masoni writes an internal email that says, we can't go to the market because we do go to the market, we know we'll lose. So we have to continue here, we have to find a way of extending this contract, but it can't be to go to the market, it can't be to a competitive tender process. So this email is now more updates on discussions between BAIN and SARS around extending this contract.
Could I direct your attention to the piece under the heading Feedback from Ronald, first dash said that we should not be concerned by the procurement/legal process. They still need to provide feedback to him and JED on the way forward, but if they cannot formally extend the contract, they will copy/paste the information in a new agreement. This will not need to go through the typical process with RFB. Matsubani said there would be a deviation justified as in phase 2. Brackets. The difference with phase 2 is that they have all the documents ready, those brackets. So your understanding of the way in which the next phase was dealt with?
Chair, so firstly, it confirms that they figured out some way of justifying a deviation in phase 2. Now for phase 3, this reference to JED, I won't be able to say his surname, but JED was the head of the customs part of SARS. And so the 3 phases of work had started with phase 1 was focused on SARS structure and operating model. Phase 2 was SARS structure and operating model, and begun to do work on customs. And then phase 3 was going to be almost entirely work on customs. So that's the relevance of them saying, you know, JED seems to be, support this going forward. But how they then did this was very creatively, again, of saying we can't go back to the emergency argument or the single source argument. The argument now was, if we don't do phase 3, then phase 1 and phase 2 would become meaningless. It would have no impact on SARS. And in fact, it would render that as wasteful expenditure. And so our hands are tied. We have to do phase 3, otherwise we would have wasted money doing phase 1 and 2. There might be many arguments for why that doesn't hold water, but one is, like I just described, phase 3 was focused on customs. So even if it didn't do phase 3, the work done in phase 1 and 2 on the overall SARS structure and operating model wouldn't have had zero impact. So it wouldn't have been wasteful expenditure. But that was, according to, again, National Treasury, the argument BAIN put forward. And Mr. Chitangano says National Treasury found their hands tied because they didn't want to have this wasteful expenditure.
Thank you. So just to summarize on this aspect, was there ever an open tender process that was run, as far as you know, in relation to phases 2 and following?
No, Chair. There was no open tender process run.
Chair, I'm about to move on to another topic. I don't know if that is a convenient time to take the tea adjournment.
You have still about 4 minutes. We could either use that or we could adjourn now. I guess your indication is you prefer that we adjourn now.
Thank you.
Okay, we will adjourn now. We will resume at 11:25.
Thank you.
We adjourn. Okay, let's continue.
Thank you, Chair. Mr. Williams, we know that, of course, BAIN proceeded to do work at SARS, and Mr. Moyani was the commissioner. I'd like to just highlight certain aspects of the execution of that mandate, and in particular, just refer you to what has been dealt with in detail by the Nugent Commission, and that is the resignation or termination of a number of senior people. Firstly, would you look at AW 95, please? That's
Which is
at
at
page
page
507, Chair.
507.
In the middle of the page, Mr. Franzen writes to Mr. Masoni, the subject is Alert SARS, and the date is 3 December 2014. And he says, goodbye, Barry Hall, ... And then the response is Masoni to Franzen of the same date, now I'm scared by Tom. This guy was supposed to be untouchable, and it took Tom just a few weeks to make him resign. Scary. Firstly, who is Barry Hall?
Mr. Chair, Barry Hall was the Chief Operating Officer of SARS. His name was mentioned in one of the documents that BAIN prepared for Mr. Moyani, saying test BH, the COO. And so the idea was to test Barry Hall. And my sense is the test wasn't for his technical or business skills.
Your reference to test Barry Hall, that's from the 100-day TM plan, is that right?
That's correct, Chair.
Yes, and then just the comment on the tone of the interchange between the two BAIN people?
Mr. Barry Hall had a reputation of being quite a tough guy. He had been brought to SARS from Nedbank. At Nedbank, he was head of technology for Nedbank. And I think it was Minister Pravin Gordhan who brought him to SARS at the very early stages of the modernization program to build this IT capability. So my understanding of Mr. Barry Hall, he's seen as very credible in terms of IT and building IT systems, but also quite a tough guy. And so the idea that they are now seemingly almost joking, saying goodbye Barry Hall, Mr. Masoni is saying, this guy, I read it to be meaning Mr. Hall, this guy was supposedly untouchable. But just after a few weeks, Mr. Moyani was able to get him to resign. So in my sense was that they'd already said we were going to test Mr. Hall, and this seems to have been the resolution that Mr. Hall is not going to be part of the future, so he's gone, and so goodbye Mr. Barry Hall in almost a joking way.
You might or might not be able to answer this question, and in which case you can say that you are not able to. Would it be fair, or let me ask it this way, do you think there is a connection between Mr. Hall's departure from SARS with what BAIN said, or somebody from BAIN said, in one of the emails we looked at yesterday, where they were talking about Mr. Moyane having to neutralize certain people. I can't remember what the other word was, but I remember.
Watch out.
Watch out, yes. And are you able to say anything, or you are not able to say anything?
Chair, I think the BAIN document answers that question, because on the slide, on the page right before that document where they describe the watch outs and the neutralize, it's on that page where they say test Barry Hall. And so for me, he was probably...
Or they specify him.
Him only.
Yes.
So
Yes.
they describe the neutralize watch-out process in general.
Yeah.
So they say, hey, you can go in there, do this, label the watch-outs, label the
Yes.
neutralize guys.
Yes.
But within all of that, there's going to be a specific guy you must watch out for and test. And this is Barry Hall.
Okay. Mr. Franklin?
Mr. Franklin, apologies, Chair, if I can just add, just again, part of the relevance of Mr. Barry Hall, he had 70% of SARS staff, 70% of the operations reported into him. So he was the key guy who made SARS function.
Yes, just so that it is clear for the Chair, if we could go back briefly to the TM First 100 Days document, which is at page 492 and is AW92. Please look at the second page, 493. Are those the references that you have been making? Let's look at the top right-hand side of the page under the heading Keep the Ball Rolling. The fifth bullet point, testing BH. Is that what you're talking about?
I can't see it. So page 493.
Yes.
Take control.
Under the heading Keep the Ball Rolling.
Oh, that's correct, Chair. So page 493, the column Keep the Ball Rolling, the very last point there is testing BH and assessing performance at different components of COO perimeter.
Okay. And but BH was not COO, is that correct? Or was
He was the COO.
He was the COO. Okay.
Yeah.
Okay.
And later we know that Mr. Jonas Makwakwa becomes the COO.
Okay.
And then just to complete it, at the bottom of the page, the last bullet point under the heading Build a Healthy Sponsorship Spine to Accelerate Change and Identify Individuals to Neutralize. The last bullet point is identify individuals that could hamper change, watch outs, to neutralize. That's what you were referring to.
That's correct, Chair.
Right, then just
Thank
in
you, Mr.
relation...
Franklin.
Sorry.
Thank you, Mr. Franklin.
Thank you. Just in relation to the climate at SARS once Mr. Moyani had taken over, did you have occasion to speak to BAIN colleagues who were there at the time, 2014, 2015?
I was, Chair. Especially during my oversight period in 2018, I was able to also engage with BAIN staff. Many of them came to me wanting to tell their experience of what happened when they were at SARS. Many of them, in my mind, traumatized by what happened at SARS.
All right, let me just take you to a couple of annexures in that regard. Would you look firstly at AW 127, page 621. In the middle of the page, we have an email from BAIN Investigation. Was that a general email address that relevant people were part of?
This was the email that Baker McKenzie used to give the BAIN Investigation updates. It was their email address they used.
Right. It's dated the 18th of December 2018, so this is during the Baker McKenzie investigation. And Baker McKenzie say the following: I wanted to bring the whistleblower email below to your attention. Just before we get to that email, you see the person whose name it is. Have you had any communication with that person and indicated whether they are concerned or not to have their name revealed?
Chair, I've never met this person, but I sent her an email and asked her, firstly, told her I'd like to include her testimony or her feedback in my affidavit. Would that be okay with her? And she gave her permission to include her name and her her testimony.
All right, so this person sends an email dated the 18th of December 2018 to the BAIN investigation team, and she says, "Dear Baker McKenzie team," and indicates on page 622 that she was a former BAIN employee over the period 2015 to 2018. She said, although primarily based in Washington, D.C. during her BAIN tenure, she spent September 2016 through April 2018 in the Johannesburg office, and she was staffed to a SARS case from September 2016 through to early February 2017, while she was a second-year consultant. Just looking at the third paragraph, she sets out what her experience was like during that assignment. Is that correct?
That's correct, Chair.
And could you highlight for the Chair the features that she had communicated to the Baker McKenzie team?
Chair, this consultant, firstly, because I often refer to them as junior consultants, as a partner, she would be a junior consultant by my measure, but she's got an undergraduate degree, she's got a master's degree from the Wharton School, an MBA from Wharton School, so a highly educated, highly accomplished person. And she describes in detail her awful experience being a BAIN consultant working on the SARS project. She says almost immediately, it was apparent to me that we were not, in fact, creating any value for the client, and that the clients were largely uninterested in us. In another part, she says, our work there was effectively a sham. Something was simply not quite right. I tried to communicate this to management, meaning her BAIN superiors, and she mentions those who she communicated this to. But the work we were doing was unethical, she says. And I felt my personal ethics were being compromised by the position I was put in while serving on this project. I shared this concern with a partner in Washington, D.C. And again, twice she shared her concern with a partner in Washington, D.C. And I requested to be removed from the project in January 2017. I think just lastly, the last comment, her view is, she had this awful experience. She didn't just keep it to herself. She shared it with senior people in BAIN and was dismissed. I told my supervisors that something wasn't right, and I told the partner that something wasn't right, and I was brushed aside. My complaints were dismissed.
All right, in similar vein, would you turn over the page to AW 128, page 624? There is another email which is addressed to BAIN Investigation 5 November 2018, and that's another one that was brought to your attention. Is that correct?
That's correct, Chair.
Now, this particular person, can you indicate to the Chair whether this person is aware of and is happy to have their name revealed?
Chair, despite what BAIN says in their affidavit, I do have this person's permission as well to present his opinions and feedback.
All right, so what this particular person says at page 624 at the bottom of the page indicates he was a BAIN employee from November 2015 to August 2016, and for the duration of that time, he was 100% assigned to the SARS case and worked on 3 work streams, and he then identifies what those work streams were. Then over the page at 625, he gives the BAIN team an indication of what it was like to work at SARS. And once again, could I ask you to highlight those observations that are relevant to an understanding of what the climate was at SARS at this time?
Chair, again, this consultant, highly accomplished, with a degree from UCT and a master's degree from INSEAD. So I refer to him as Junior, but again, this is an accomplished person. He says, the SARS staff were highly skeptical of our presence at their offices. He describes that one of his tasks on the team was to share media reports, media articles with us, with the BAIN team, of what was happening at SARS. And then the moment negative stories started coming out about the rogue unit and other things happening at SARS, he was told to stop doing that, to selectively share the news articles within the BAIN team. But he goes on to say that senior management resistance was obvious, referring to SARS senior management. The SARS senior management resistance was obvious through the organization work. This was the restructuring work. But again, the perspective was landed upon me that was to power through and get it done. It's this idea that despite SARS senior management being resistant to BAIN's work, the BAIN team were told to power through and just to get the work done. And then just lastly, one of his comments, what does stand out for me was the arrogance with which the Moyani, Zuma, BAIN links were dismissed. And I think he's referring to the media articles were saying there's obviously a link between Moyani, Zuma, and BAIN. And within BAIN, he's saying the arrogance with which they dismissed this link and the general acceptance that came from the floor, meaning the team, as the project grew ever more work streams. The feeling that we were smarter than them and we will have our facts ready if they come for us was one definitely felt throughout the team and his time at BAIN. He says, I also felt leadership were dismissive of the reports when they first surfaced at the end of 2015.
Just for the record, are you referring there to the second last paragraph on page 625?
That's correct, Chair.
Right, I'd like to take you now to certain press releases which were issued by BAIN in the course of the Nugent Commission workings. Would you first please go to AW3 at page 125. I think you identified that earlier as being a BAIN statement that was sent to the BAIN team. So that was an internal document. Is that correct?
That's correct, Chair. It was sent to the BAIN team and BAIN's alumni.
And you had commented that the statement trivialized the real impact on BAIN alumni. Is that right?
That's correct, Chair.
But then please look at AW6 at page 132. Is that a BAIN press statement that was issued to the public in general? It appears on or about 2 September 2018.
That's correct, Chair. It was a public statement presented by BAIN.
All right, this takes us back to the beginning of your testimony and the reason for your appointment, but we didn't highlight what was said by BAIN. So in the first paragraph, it's recorded that in light of new questions being raised during last week's testimony before the SARS Commission of Inquiry and from media inquiries, BAIN & Company is now undertaking a deep and extensive investigation led by our global leadership and external counsel into all matters relating to our work with SARS. We want to be absolutely certain that we entered into our SARS engagement in full compliance with applicable procurement laws and that our investigation's findings are accurate and unassailable. And then the second paragraph, just the first sentence, we want to be completely open and transparent as we believe that is what the people of South Africa deserve. Could I then take you to the fourth paragraph where the following is said? We have listened with concern to the testimonies of SARS employees who feel they have been mistreated and disrespected, at their frustration and pain and the consequences this has had on the lives of these individuals and their families. We are dismayed by the way our work has been used to further a different agenda than was intended. in our recommendations, there was no need for any layoffs or terminations. This didn't turn out to be the reality when the model was implemented. We are deeply sorry for how this turned out. We wish we had known then what we do now. If I could then ask you to look at AW10, page 142. This is a further press statement dated the 10th of September, AW10, page 142. Do you have it?
I do, Chair.
The second and third paragraphs are as follows. To understand what happened, we launched an independent investigation led by the global law firm Baker McKenzie. The investigation is focusing on understanding the facts relating to people, processes, and governance that related in us getting and accepting the work. Our own internal review established that our engagement with SARS did not meet our standards for delivery of sustainable positive results for our clients. We do not want to benefit from work that was used to further a different agenda than was intended. Just pausing there, there have been a couple of references to a different agenda. Do you know what that is a reference to?
Chair, my understanding of that reference is BAIN is asserting that they went into SARS with complete legitimate and wholesome intent, and they were unwitting participants in some agenda to damage SARS. And so while, by their version, yes, they were there at SARS while this was all happening, it was completely without their knowledge. And so apparently expressing regret for having been there when this was all going on.
Then there's a further press release, which is at AW 45, page 252. We have looked at it briefly before. This is 17 December, I presume, 2018. You have that?
Yes, I do. And East 2018.
All right, if I could just take you to some of the paragraphs. The first is, the past few months have been a highly challenging and sobering period for BAIN South Africa and BAIN globally. Through public testimony and documents submitted at the Commission of Inquiry headed by Judge Nugent, it has become painfully evident that the firm's involvement with the South African Revenue Services, SARS, was a serious failure for South Africa, for SARS, and clearly for BAIN too. The Commission's hearings and the final report published last week have laid bare the disarray in which SARS now finds itself, with both morale and performance severely damaged.
Mr. Franklin, you left me at 142.
I'm sorry. This is page 252.
252.
Correct, and that is Annexure AW 45.
Okay, I've got it, but I did listen as you were reading.
Thank you. So there appears in those first two paragraphs to be an acknowledgement that things went wrong. On this right-hand side of the page, you will see what BAIN writes is that we clearly made significant errors of judgment on taking on this work. And then in the third paragraph, we accept that through various lapses in leadership and governance, BAIN became an unwitting participant in a process that inflicted serious damage on SARS. Just your comment about errors of judgment and being unwitting participants?
Chair, on my read of the multiple emails that indicate that BAIN knew about Mr. Moyani's appointment coming, on the nature of the content of the materials that BAIN had presented and prepared for and with Mr. Moyani, the way the procurement process worked, which seemed obviously to be irregular, all of this indicates to me that BAIN did not arrive at SARS as unwitting participants. In fact, it appears to me on the reading of those facts that BAIN arrived at SARS, as apparently Mr. Moyani did, with a restructuring agenda. It was designed months before either of those parties arrived because it's there in the documents. The TM 100 days and the previous document, the SARS 2.0 documents, lay out the plan for restructuring. So to say that they arrived and they're shocked by what happened and they were unwitting participants, for me, just doesn't accord with what the evidence I've seen.
As part of your oversight function, you were concerned to ensure that all material information was placed before the Nugent Commission. Is that right?
That's correct, Chair.
We know that Mr. Masoni testified. We know that Mr. Min testified. Apart from those two, did any other BAIN employees testify?
Chair, Judge Nugent invited BAIN to present any witnesses they wanted to. In fact, he created a whole day during the Nugent Commission for BAIN to send any witnesses, and no one, and BAIN declined that invitation.
Please look at your affidavit at paragraph 158, page 75. There you've said that it was clear to BAIN who the Nugent Commission would be interested in speaking to as witnesses, and you've referenced an email from Mr. Kennedy on the 28th of September 2018. Did Mr. Kennedy identify people who would be of interest to the Commission in his view?
Chair, Mr. Kennedy does. So Mr. Kennedy was leading from the BAIN's legal standpoint, and he identifies in his email who he thinks the Nugent Commission might be interested in speaking to. And he names them as Fabrice Franzen, which makes sense because he headed up the BAIN project and ran the day-to-day operations. And he identifies Stefan Timpano, who we know had drafted many of the materials that BAIN had presented to Mr. Moyani and to the President. Because this is relevant because BAIN, the narrative BAIN advances is that only Mr. Masoni knew what was going on, and he was now gone. So there's no way we could know what happened. But it's interesting that they identify people internally who could have added, shed light on what happened.
Would you look please at AW143, page 664. In the second half of the email string, you'll see one from Mr. Kennedy to Mr. Min, dated 3 October 2018. And he says, just thought I'd give you the key points from the call. He says, Athol's list of additional witnesses does make sense in the context of the DOJ. Now, just stopping there, what is Athol's list of additional witnesses?
Chair, Baker McKenzie had prepared a list of BAIN employees who they were going to interview to gather additional information as part of their investigation. And when I saw that list, it seemed to omit very obvious members of BAIN's senior team who should be there. And so I submitted, based on my own read of it, a list of people who I felt needed to be included in that list of witnesses with the interview.
I don't believe we have that email with your list of witnesses. I might be wrong. But do you recall offhand who you thought were obviously of interest and ought to testify at the Nugent Commission?
Chair, I don't think we've got that list here, but my recollection were, there were obvious people. There were people like Paul Meehan, who was Mr. Masoni's boss. Surely he should be interviewed. We heard the name Wendy Miller yesterday, who was BAIN's global head of marketing, who was involved in a lot of the discussions around the Amberbright contract. Her name was not on the list. In fact, I suggested that Mr. Stuart Min, who was BAIN's head of global legal, should be on the list because he had knowledge of what was happening with the Amberbright. And a few others. I think even Fabrice Franzen was. There were some operational people who were just obvious, who would know something, were not on that list.
Then look at paragraph 160 on page 76. There you've said not only was BAIN withholding witnesses from the Commission, they were also excluding key BAIN people from the investigation. I was contracted to oversee. Given the facts of the situation, it seemed extremely odd to me that Baker McKenzie was not planning to interview, and then you give a list of people. Could you identify those people and briefly explain to the Chair why you believed they were obvious topics of subjects for interview?
Chair, so I'll start with Stefan Timpano. We know he was involved in preparing the materials that BAIN presented to President Zuma, to Mr. Moyani on SARS. So I suggested he needed to be interviewed. I mentioned earlier Mr. Paul Meehan, who was Mr. Masoni's boss. Not only did he have knowledge of what Mr. Masoni was doing, he would have seen Mr. Masoni's personal assessments. So Mr. Meehan, they mentioned Mr. Min, Mr. Stuart Min was head of global legal. He seemed to, in my mind, be directly involved in many relevant discussions in his role as global head of legal for BAIN. And then I mentioned Ms. Wendy Miller, who had raised many of the concerns. I would have thought she'd be instrumental because if she raised the concerns and someone overrode those concerns, it might have been interesting to know who that person was. I mentioned Christopher Cameron, who was a senior BAIN manager. He worked on the SARS project. So again, from an operational on-the-ground standpoint. And in fact, I mentioned Chris Kennedy, who was senior counsel at BAIN, because he in fact had negotiated the SARS contract. So when BAIN had engaged with SARS at the outset, it was Mr. Kennedy who negotiated that contract and was intimately involved. Chair, BAIN didn't have any legal capability in South Africa. So they relied on BAIN's legal capability in Europe and the US. And so whenever there was anything legal, it would have involved Mr. Kennedy or others.
As far as the investigation by BAIN, which you say began as a short ad hoc investigation by BAIN itself and then was taken over by Baker McKenzie, as far as that is concerned, could I ask you to look at the document at page 160, which is AW14, a letter from Baker McKenzie, dated the 25th of September 2018, and it's headed BAIN South Africa Investigation Plan. Right, just to highlight certain features, the background at 1.1 records that this plan governs the investigation of BAIN, contracts with SARS, which is to be conducted by Baker McKenzie, and it records that BAIN commenced the investigation in response to questions raised by the Nugent Commission. And then in 1.3 it sets out what the investigation will address, the various questions it will address. It gives the scope of the investigation in paragraph 2, and it gives the investigation methodology in paragraph 3, which includes interviews. Just pausing on interviews, did you ever see the interview notes of interviews that were conducted?
No, Chair, I did not. Despite continuous requests and urging and appeals, access to the interview notes was denied to me.
Then 3.6, reporting of findings and independence. But before we get into the detail of that, what was your understanding, having been appointed and with the background which led to your appointment, what was your understanding of the ultimate objective of this investigation and whether it would be reported on, and if so, to whom?
Chair, my understanding was that this was a real sincere attempt and effort on BAIN's part to really understand what happened at SARS and BAIN's involvement at SARS and with some of the other state entities. I really believe that BAIN was shocked by what had happened and what they'd heard, And so this was a comprehensive investigation to really get to the bottom of what really happened. BAIN had made very clear to me, to their staff, and to the public, that the intent was to be open and transparent with what they find. So much so that they hired me to give the public and the Nugent Commission some assurance that what they find will be reported truthfully. And so my understanding of this process, the investigation was, I would see everything that Baker McKenzie finds, and at the end of the investigation, Baker McKenzie would produce a report of these findings, against which I could then write my report, reporting on whether I believed they had both conducted a comprehensive investigation and reported those findings truthfully.
Let's then proceed to examine what happened in fact. Firstly, was a final investigation report by Baker McKenzie ever produced to the Nugent Commission and or the public?
No, Chair. Baker McKenzie or BAIN, Baker McKenzie nor BAIN presented a report to the Nugent Commission, nor did they make a report public of their findings.
Was that contrary to the plan that persuaded you to agree to play a role?
That's correct, Chair.
Yeah.
It was contrary to what BAIN had said publicly, what BAIN had said internally, what BAIN had said to me, what BAIN had said in their contract with Baker McKenzie, and what BAIN had said in my contract with BAIN.
Mr. Franklin.
Thank you. Let's just establish when you found out about this. AW160, page 796. That is an email string. Would you look at the email in the middle of the page? It's from you to Chris Kennedy and Mr. Moorman, dated 11 December 2008.
2018.
Sorry, 2018. And you've said, I think BAIN not releasing investigation findings will kick up a media storm. I don't use your exact words. I take it you had found out at or about this time that there was no intention to release a report. Is that right?
That's correct, Chair. My role was about oversight, but I also felt that I had a responsibility to nudge BAIN towards doing what I thought the right thing was, because that's what they wanted me there to do. And so part of the assurance to the public and to Judge Nugent was that I would also advance this effort to do the right thing. So when BAIN said they're not going to release the investigation findings, I said that's going to be massively problematic. And so raised this concern here, as I did in many other places.
They give you their reasons why they were saying they would not release the report to the public, and they would not, as I understand the position, even give it to you, despite the fact that they promised the public that they would be transparent about this investigation.
Chair, my understanding is based entirely on an email that I received from Mr. Kennedy, because I asked that question. And the answer to me was that the findings of the investigation would be problematic for BAIN if they were public, because they were likely to attract prosecutions. Sorry, let me rephrase it, apologies. They were problematic because they could be used against BAIN should they be prosecuted. And that would be problematic in South Africa and in the United States. So the findings were there. They looked at the findings. In my interpretation, saw that what was there pointed to some wrongdoing or improper behavior, and then said there's no way we can make this public because this will hurt us if there was a prosecution.
Yeah, it would seem obvious that if the findings were favorable, they would have made them available.
That's absolutely my understanding.
Yeah. Okay. Mr. Franklin.
Thank you, Chair. Just on the Chair's question, the email at the top of the page appears to give a reason. Is that correct?
This is an email from Mr. Kennedy to me. Yes, this question had been discussed. referring to my question about, this would be a problematic if BAIN didn't release the findings. It was the very clear advice from Baker McKenzie that they should not release their findings to me, to the public.
Then please look at AW162, page 801, an email from you to Nicola Wilson and Mr. Mulman, dated the 11th of December 2018.
What's the page number again?
It's 801, Chair.
801.
But this all seems to have happened on the same day, and this is later in the day, to the emails we saw at page 796. And what you say is this in the second paragraph: I understand from Baker McKenzie and Chris Kay that Baker McKenzie's investigation findings will not be documented in a report. This is a significant change and complicates things for me. Would have appreciated being informed of this change proactively by somebody at BAIN rather than have me deduce it from the discussions with Baker McKenzie. I have communicated to Baker McKenzie and Chris that I will finalise my report based on what I know and including this new development. Why did you address this to Nicola Wilson?
Nicola Wilson was head of marketing and public relations at BAIN in South Africa. She was one of the people who I dealt with internally. So it was either Mr. Moorman who was acting, Chair, either Mr. Moorman was acting office head, or Ms. Wilson. I did copy Mr. Moorman in that email, saying this was a surprise to me to hear. And Chair, there's reference to I had to deduce this. At no point, so the plan was very clear. Baker McKenzie were going to develop their findings, produce a report, it was going to come to me. At no point did BAIN or Baker McKenzie say, Athol, we've decided not to send you this report. It kept coming up and I was saying, guys, when will I see this report? When will I see this report? And it was this sort of back and forth. And eventually I then said in an email, am I going to see the report? And they said no.
Then please look at AW166, page 809, which is an email from you to Mulman and Kennedy and others, dated 14 December 2018. And I think it's true to say here that you vent your spleen on this topic. And you have said that although BAIN repeatedly committed to doing the right thing, this latest development was a problem for you. Could you just elucidate what it is that you said and why?
That's correct, Chair. As we discussed yesterday, I engaged with BAIN, one, because I had this history with this company, I had this long history with this company and a very proud history with this company. Two, that they gave me assurance, all the way top to the worldwide managing partner, that they were going to do the right thing. And they contracted with me very specifically about what my role was going to be. There was no doubt in anyone's mind what it was going to be. There were even times where BAIN asked me to stand up in front of their staff, to calm the staff down, to give them assurance that the right thing was being done. In those meetings, I described the process that was going to unfold, where the investigation would happen. I would see the report. We understand there might be some sensitivities in the report, people's email addresses or bank account details, etc., so that might be excluded. But I would see the full report, full investigation details, and I would offer an opinion on whether that was truthful or not. That was very clear, Judge. And I'd stake my reputation on this. Externally, there were so many people who were my trusted associates who said to me, Athol, what are you doing? And I was saying, guys, this process is going to be a first in the country, because here's a company who says, we know we've done wrong and we are going to investigate it and report it. So for me, there was a lot at stake in this happening according to that process. So when it became clear to me that BAIN were now deviating from that process, That upset me because it meant that they'd lied to the public, lied to the staff, lied to the authorities about what was going to happen. And it appeared that I was part of that lie because I was there. And so I wrote to the most senior people who I dealt with, Mr. Moorman, Mr. Kennedy, Mr. John Sr., who had replaced Mr. Masoni as head of the South African office, and Mr. Hutchinson, laying it out very clearly that what is happening here is unacceptable, that BAIN had consistently said they were going to tell the truth and reveal the report, reveal the findings, and now they were not doing it. And at the end of this email, Chair, I say it's a request. And I say, I would like to urge BAIN to fulfill the promise made to the South African people to be completely open and transparent by making a version of the investigation findings public and allowing me access to all the relevant evidence and documented findings so that I can act without restrictions. And that phrase, without restrictions, wasn't public, was in my contract. This access will allow me to conclude my oversight role and write my final report. You asked me to stand up in front of the Joburg office on a few occasions to describe my role. And I go on to say, basically, in the absence of you sharing this with me, you are actually blocking me from completing my duties.
Then paragraph 201 on page 89 of your affidavit, please. Would you go to that? It appears that on 19 December 2018, you were eventually shown something. Is that right?
Not exactly, Chair. I was invited to be shown something.
Right. Will you explain what you were invited to see and what you did or didn't see pursuant to that invitation?
So, Chair, as you could tell from those emails that I'd sent, I was urging BAIN to let me see the findings because that would allow me to complete the duties that they'd hired me to do. What Baker McKenzie and BAIN then got to, the point they got to was saying, we can show you the report, you can't print it or take it away with you, and you can't make reference to it. So you can't talk about having seen this report, but we will show it to you. And I said, I reject that. That makes no sense for me to say I've seen something when I actually haven't seen it. So I rejected that. They then came back and said, okay, we've got another plan. We'll do a link with you, some technology link, where the report appears on your laptop, and I can see it, but I can't download it or print it. So on the 19th of December, this meeting was set up with Baker McKenzie and BAIN and myself. It was remote. I was in Cape Town, and they were scattered around the world. And I was to see this presentation. I was to see this report. So the meeting was set up. It was clear I was going to receive the report. Halfway through the meeting, I still hadn't seen the report. And so at that point, I asked, when am I going to see the report? And the Baker McKenzie partner, Reagan Demas, was in the United States, kind of said to me, well, why do I want to see this report? They will read it to me. I said, well, that doesn't make sense to me at all. It's like you're describing a painting to me. I haven't seen the painting, but I claim I've seen the painting because you describe it to me. That was exactly the metaphor I used on that call. And he said, no, but he's going to read it to me. Do I think he'll lie to me? And of course, it wasn't the point. The point was this meeting was set up for me to see the report. And so I was extremely angry and ended that call because it was clear that BAIN were not going to show me this investigation report.
As regards your own reporting, Mr. Williams, would you look at AW154, page 694? Can you confirm that that document from page 694 to 733 is an interim report dated 20 November 2018, which you submitted to the Nugent Commission?
That's correct, Chair.
Then AW155 at page 735 can you confirm that that is your final report to the Nugent Commission dated 20 December 2018?
Chair, this is my final report.
Yes, sorry, my mistake. It wasn't submitted to the Nugent Commission. The Nugent Commission had completed its own report by then. Is that right?
That's correct, Chair. And the reason this was late to submit to the Nugent Commission was I kept waiting for BAIN to give me the investigation report. And the reason I did the interim report was to give something to the Nugent Commission in terms of reporting from me, and Judge Nugent made extensive reference to my interim report in his final report. But I could not get from BAIN the final report from Baker McKenzie in time to produce a final report in time for the Nugent Commission.
All right, that report speaks for itself. You have dealt with a number of topics therein. I take it that you stand by the conclusions which you reached.
Chair, I stand by the conclusions I reached at that point with what I knew at that point.
And just taking that further, did you acquire further knowledge thereafter which informs your present view of the SARS engagement? And if so, what was that further knowledge?
So, Chair, my view now is different to what I expressed in this report. And two things lead to that change of view. One is the additional experience I have with BAIN. So this runs up to December 2018. As you know, I then spent another 8 to 9 months with BAIN. And so that experience added to my knowledge of what really happened. And so it caused me to change my view. And secondly, I then, after making contact with the Zondo Commission, I then went and reviewed all of the materials I had. And that informed a different opinion. So what I reviewed at this stage led me to a particular view. When I had this broader experience with BAIN and reviewing all the materials I had, I formed a different opinion.
All right, could I ask you now to turn to a different file, which is SARS Bundle 03 and Exhibit WW6. Please look at page 12 in SARS 03. You will see that that document running from page 12 to page 37 is an affidavit deposed to by Mr. Moyani dated the 3rd of March 2021. And in it, what Mr. Moyani has done is to address various themes and to answer allegations that have been made against him by various witnesses who have either been called or are to be called in the Commission. You've read this affidavit?
I have, Chair.
Please turn to page 29.
Chair, can I restate that? Apologies. I haven't read the entire affidavit. I was provided with sections of this affidavit that apply to me.
All right. That's what I wish to refer you to. The section at paragraph 62, page 29, to 68, page 35. Now, I'm not going to read the entire version. I'm going to just highlight certain of the allegations made by him and ask for your response. Paragraph 62, page 29, he says he's never met you, but says you're a self-styled whistleblower and a determined and disgruntled former employee of BAIN who is on a mission to implicate his former employer in alleged wrongdoing, rightly or wrongly so. What's your reaction to that allegation against you?
Chair, it's interesting that someone can say they never met me, but they've got such a clear description of me. describing me as a disgruntled former employee. Chair, my response to that is, I understand a disgruntled person as someone who's angry and dissatisfied with the situation. And so I'm inclined to agree with Mr. Moyani that I'm disgruntled. Because I'm angry and I'm dissatisfied with the corruption in our country. I'm dissatisfied and angry about what happened at SARS. I'm angry and dissatisfied at what BAIN has done to cover it up and be involved in it. So yes, I'm disgruntled. It might not be for the reasons he thinks I'm disgruntled. In fact, I think all of South Africa is disgruntled, angry and dissatisfied with what has been happening in our public institutions.
Secondly, in paragraph 64, he summarizes your allegations against him in a number of propositions, which we don't need to go to. It's his summary of what he says you say. He concludes in paragraph 65, it is not clear how all the above, if true, translates into my personal involvement in or knowledge of state capture or even the capture of SARS, and if so, for what unlawful purpose. So you can read 64 if you wish, which is Mr. Moyani's summary of your allegations against him. But would you react to his contention that even if those allegations are true, it's not clear how this translates into any knowledge of state capture or the capture of SARS?
Chair, I don't feel I'm in a position to respond to that. What's determined to be unlawful? I just don't think I know enough to determine whether what I observed was lawful or unlawful, or what I've read and understood was lawful or unlawful. I do have a sense a lot of it was improper and unethical and not becoming of a leader of a public institution. So if the evidence I've seen is correct, that Mr. Moyani planned with BAIN to enter SARS, to cause damage at SARS, which is what the evidence seems to suggest to me, and I do think that's improper and unethical. I can't make the assessment on lawfulness or not.
Fair enough. Paragraph 66, he sets out his own version of events, which he says, let me just read it. I nevertheless wish to narrate the following version of events so that the mind of the Commission can be put at rest about the absence of any possible state capture motives on my part. He then sets that out. I don't think it directly implicates you.
Mr. Franklin, if I may, and maybe this is a typo in Mr. Moyani's affidavit, at 66.3, he says, at some point in the very early part of 2013, the President informed me in strict confidence that he intended to appoint me to the position of SARS Commissioner. If that's correct, then it changes the narrative we've been working on quite substantially, that the President could have informed him in early 2013. I suspect it's early 2014, but...
yeah, this is early 2013.
Still makes the point that he was informed very early on that he would get the job.
But this is strange because in paragraph 66.1, it says sometime, probably in the second half of 2013, the position of SARS Commissioner was advertised in the mass media. So if the President told him in the very early part of 2013 that he intended to appoint him to the position of SARS Commissioner, he says, for which I had applied. How could he have applied before the position was advertised? Or am I missing something here?
I agree with, sorry, I agree with you, Chair. That's I'm affording Mr. Moyani the benefit of the doubt by saying it was a typo. Yeah. But if it's not a typo, it does raise more serious questions.
Yes. Yes. It's very interesting because he talks about the general election He says at 6, well, he says, just to complete that paragraph 66.3, which you started reading, Mr. Williams, at some point in the very early part of 2013, the President informed me in strict confidence that he intended to appoint me to the position of SARS Commissioner, for which I had applied. He explained that his intention should be kept under wraps, as he only intended to formalize it if he was still in office after the general elections, which were scheduled to take place in May 2014. And then he says at 66.4, I fully understood that the decision was obviously conditional upon the happening of 3 political or constitutional events, namely the ruling ANC would win an outright majority in the 2014 elections, and then there are other matters connected with the election and the election in Parliament of the President. But he mentions 2013 in 3 subparagraphs there. First, he says at 66.1, sometime probably in the second half of 2013, the position of SARS Commissioner was advertised in the mass media. 66.2, in or about early September 2013, I submitted a formal application. I did not do so at the suggestion or instigation of any person. By then, I was already a veteran civil servant, having held several key positions in the civil service. Then, at this point, Mr. Williams' affidavit?
No, I haven't.
Okay, we must make sure we do that before
Yes.
we finish. I just remember now that we are looking at this one.
Yes.
Yeah.
And the purpose of this present exercise is just to indicate that there are two versions which are
Yes.
filed. I'll only ask the chair to admit the second one.
Yeah, no, that's fine.
So the first one, Mr. Williams, if you see at page 274, it's dated the 19th of March 2021. Is that correct?
That's correct, Chair.
Then the version I wish you to look at, please, is at page 275 to 322. And that version has certain annexes. Is that correct?
That's correct, Chair.
The second version, which starts at page 275, runs to page 322, and we see a date of 22 March 2021. Is that an affidavit deposed to by you on that date?
That's correct, Chair.
And do you confirm the truth and accuracy of the content of that affidavit?
Yes, I do, Chair.
Chair, might I ask that that affidavit be admitted? It doesn't have an exhibit number because it is in an application file, but
Yes.
it is identified by reference to the page numbers.
It's Mr. Williams' affidavit, and his main one would be exhibit something, maybe W1 or A.
It's WW1.
Yeah, so this we could make WW2, is that right? Or there's no other
I don't think there's another WW2.
Yeah, or unless we make it 1A or 1.1.
I think the safer suggestion is to make it WW1.1.
Yes, okay, all right. Mr. Williams' affidavit, starting at page 275, will be admitted as an exhibit and will be marked as exhibit WW1.1.
Thank you, Chair. Mr. Williams, you indicated earlier that you have read the affidavit of Mr. Min, and you have, of course, deposed to this affidavit, which has just been introduced, and in that you answer the contentions made by Mr. Min. Is that correct?
That's correct, Chair.
I'm not going to take you to all of them, but I do want to direct your attention to some of them. So I'm going to be asking you to look at the affidavit of Mr. Min and then to look back at your answering affidavit. So perhaps keep both places open. The first paragraph that I wish to refer you to is paragraph 62 on page 39. Remember always, please, to look at the red numbering in the top right-hand corner.
I'm sorry, the page is?
Page 39.
Okay.
So in paragraph 62, Mr. Min says that BAIN accepts and has publicly acknowledged that there were ethical flaws in its conduct and it made mistakes. Mr. Masoni in particular did not act appropriately in how he sought to interact with public entities and public figures and to generate public sector work. We returned to the fees we received on the SARS work plus interest. We returned the fees we received on the SARS work plus interest before the Nugent Commission completed its work. You have responded to that in paragraph 79 and 80. And could you just highlight for the chair what your response to that contention is?
Chair, my view that BAIN admits to ethical flaws is that it's completely meaningless unless they identify what those ethical flaws are. So just saying we admit to ethical flaws does not constitute some admission of wrongdoing.
Yes, and of course, if they come to the commission, they will be asked about what those flaws are.
Absolutely, Chair. It was very relevant in the context also of my role at BAIN, which was meant to plan remedy and to make amends. And as an expert in this field of thinking about remedy and reparation, the first step is to acknowledge the wrongs you did and then the harms you caused to people. How can I make amends to someone if I don't acknowledge firstly what I did to them that was wrong and the harm I caused? And so just saying there were ethical flaws, to me, says nothing.
Yes, then the second aspect that I wish to put to you from Mr. Min's affidavit is paragraph 67, page 40. There, Mr. Min says, Mr. Masoni procured Amber Bright's services to assist BAIN SA in its attempts to gain traction in the public sector. And he then goes on to describe the scope of the work. You have dealt with that at para 84, page 306 of your affidavit. And again, could I ask you to give the Chair the gist of your response to that allegation?
Chair, Mr. Min describes Amber Bright as providing services, which he says are strategic services and operational services. And I assert in paragraph 84 that just based on my reading, these services, is it okay if I just read part of this? Much easier.
I think it is.
Okay. So I say this is misleading to say that Mr. Masoni procured Amber Bright services. The truth is that BAIN procured Amber Bright services, not Mr. Masoni. So firstly, they're saying Mr. Masoni procured services. It's BAIN who procured those services. And secondly, Mr. Min writes that BAIN was unaware of the nature and full extent to which Amber Bright was facilitating these types of introductions at the time. And I respond by saying, and we had this evidence before us yesterday and today, that Mr. Min and many others at BAIN knew full well what the nature of these introductions were. Ms. Miller and Mr. Min himself wrote incredulous emails to colleagues in which he scoffed at the idea that Amber Bright's leaders as entertainment professionals were going to provide BAIN with business advice.
Right, then paragraph 71 on page 41. The assertion is there made by Mr. Min that Mr. Williams is also correct that the Amber Bright contract raised a number of red flags. Then he continues, but it only came to my attention and that of others after Mr. Masoni had procured Amber Bright's services. You've responded to that in paragraph 85 on page 306. And you've said that's not correct. Perhaps you can put that in context.
Chair, I was in a meeting, and this I've got no proof of. I was in a meeting where Mr. Min was on the phone in the US, and a number of us were in a meeting. It might have been someone from Baker McKenzie, Mr. Kennedy, were in a meeting in Johannesburg, so we were on the phone, where Mr. Min says that he objected to this Amber Bright contract. And we know that from some of the emails he seemed to be uncomfortable with the Amber Bright contract. But I say even if he only knew about the contract issues after the contract was signed, Masoni mentions that Mr. Mian knew. Am I reading the right part? Mr. Mian knew about it. The legal representatives of BAIN Global, Mr. Graham Luce, knew about it. And Mr. Masoni writes in his email to Ms. Miller, he says legal and finance had approved this contract. Now, as I said earlier, legal meant global legal. because there was no legal capability in South Africa. Finance, we know, refers to someone in Europe and the US. So this contention that people globally didn't know what was happening just makes no sense to me. And if I refer back to that meeting where Mr. Min was on the phone call, we then said if Mr. Min was overruled by his objection, we asked who then overruled. And Mr. Min asked who was in the room, and when we told him who was in the room, he said he was not going to answer that question. But it's definitely left me with the impression that Mr. Min had objected and he was overruled by someone. Now, who overrules your head of global legal, Chair, but someone very senior within your organization? So this contention that BAIN Global senior leaders had no idea what was happening here in South Africa and the detail of it, for me, I struggle to follow that.
Then would you look next at para 71.5 on page 42. There, Mr. Min says that partners in the BAIN SA office had also queried the Amber Bright relationship, particularly the payment of success fees to Amber Bright. Despite their requests, Mr. Masoni refused to provide them with copies of the Amber Bright contract beyond displaying it briefly on screen during a meeting. Their grasp of what the contract entailed was therefore vague. These concerns were escalated at the time by the local partner team to Paul Meehan, who then sought an explanation for Mr. Masoni of the, quote, rationale, benefits and risk management issues, close inverted commas. Of note is Mr. Meehan's question, inverted commas, where is the rest of the partner group on this? We had talked about getting everyone else on board before proceeding, close inverted commas, to which Mr. Masoni responded, inverted commas, the partner group is on board, Innocent and Fabrici in particular, as they are also going to be involved in the target clients, close inverted commas. He says, this was not true. And then you've read the rest of that. Could I just take you to your response at para 87, page 307? You say that in this paragraph, they, that's BAIN, try to portray Mr. Masoni as a lone rogue who was acting wrongfully and without head office's knowledge or ignoring head office's warnings. And perhaps you can just summarize the rest of what you say there.
Chair, this is anyone who studies calamities or things that go wrong in any organization will know that it's never just a lone rogue. Very rarely do organizations work where one person can do something with absolutely no one else's knowledge of it. That's just not how organizations work. And we also, myself as a business ethics scholar, have studied many occasions where corporates get things wrong. And the first thing they do is they say it's a lone rogue. McKinsey says it's one guy, they've fired him, don't worry, things are sorted. Steinhoff says, don't worry, Marcus Joyce is out, it's sorted. That's the first response, and that's a cop-out. Because there's always a number of people who know what's going on. So BAIN continuously, in their media, internal communications everywhere, seems to say to us, the world, the public, there was a bad guy, he did these bad things, we didn't know about it, but don't worry, we've got rid of him. So now everything's fine, nothing to see here. And I make the point that, firstly, my expertise and any common sense would suggest to you that's not possible, that no one knew what was going on. But even if you ignore my expertise, just looking at the facts of the evidence we've seen, of the email exchanges, of the self-assessment reporting, of the meetings that were going on, BAIN is a partnership. It's not a corporation, it's a partnership. So the partners would have known what was going on in South Africa, around the world. So this contention,